Dear viewers, in the last session we discussed shareholder and member. In this session we are going to discuss share and share capital. The objectives of the lesson are, by reading this lesson, the reader will come to know the concept of allotment and the procedure of allotment of shares. The reader also will come to know the procedure of transfer of securities of the company and also the concept of issue of shares at premium and sweat equity shares. Section 39. Allotment of shares. In Gopal Jalan and Company versus Calcutta Stock Exchange Association Limited, AER 1964, Supreme Court, page 250, where a prospectus is issued by a company inviting offers from the public to subscribe for its shares. A person who applied for shares makes an offer to subscribe for them, and the company accepts the offer by allotment of shares. Statutory restrictions with reference to allotment of shares. 1. Section 39. Minimum subscription and application money. When shares are offered to the public, the amount of minimum subscription has to be stated in the prospectus. Companies Act 2013 and Companies Prospectus and Allotment of Securities Rules 2014 did not prescribe the amount of minimum subscription. So, the company has to disclose the minimum subscription amount in the prospectus. If the stated minimum subscription has not been subscribed and the sum payable on application is not received within a period of 30 days from the date of issue of prospectus or such other period as may be specified by the SEBI, the amount received shall be returned within such a time and manner as may be prescribed. The amount payable on application on every security shall not be less than 5% of the nominal amount of the security or such other percentage or amount as may be specified by SEBI by making regulations in this behalf. Whenever any company having a share capital makes any allotment of securities, it shall file with the Registrar of Companies a return of allotment in such manner as may be prescribed. In case of any default under section 39, subsection 3 or subsection 4, the company and its officers who are in default shall be liable to a penalty for each default of 1000 rupees for each day during which such default continues, or 1 lakh rupees, whichever is less. Section 40. Shares to be dealt in on stock exchange. Every company intending to offer shares or debentures to the public by the issue of a prospectus has to make an application before the issue to any one or more of the recognized stock exchanges for permission for the shares or debentures to be dealt with at the exchange. This is known as listing. Stock exchanges charge their fee for listing agreements. Provisions of Securities Contract Regulation Act 1956 are applicable to the subject. The requirement is not merely to apply but also to obtain permission. The name or names of the stock exchanges to which the application has been made must also be stated in the prospectus. Listing of shares on stock exchange has been made compulsory. It is a condition precedent for listing permission that the application money is deposited in a separate bank account and is to be used only for adjustment against allotment of securities if the securities have been permitted to be dealt within the exchange or exchanges specified in the prospectus. Otherwise, the money has to be used for repayment to applicants within the time specified by SEBI if the company is for any other reason is unable to allot securities. Any condition purporting to require or bind any applicant to waive compliance with any of the requirements of the section is to be void. If a default is made in complying with the provisions of the section, the company is to be punishable with fine which is not less than 5 lakh rupees but which may extend to 50 lakh rupees. Every officer in default is punishable with imprisonment for a term extending to 1 year or fine not less than 50,000 rupees extending up to 3 lakh rupees or with both. The company may pay commission to any person in connection with subscription to its securities subject to such conditions as may be prescribed. The object of the section has been explained by the Supreme Court in Union of India versus Allied International Products Limited, 1973, Supreme Court cases, page 594. The object of the provision is to enable shareholders to find a ready market for their shares so that they can convert their investments into cash whenever they like. Section 41, Global Depository Receipt. A company may, after passing special resolution in its general meeting, issue depository receipts in any foreign country in such manner and subject to such conditions as may be prescribed. Section 42, Private Placement. A company may make a private placement through issue of offer letters for private placement. Provisions of Section 42 become applicable to such placement. The offer of securities or invitation to subscribe for securities can be made to a number of persons but not exceeding 50 or such higher number as may be prescribed. This number is not to include qualified institutional buyers and employees of the company being offered securities under a scheme of employee stock option as per the provisions of Section 62, subsection 1, clause B. This can be done in one financial year and on such conditions as may be prescribed, which is to include the form and manner of private placement. Section 42, subsection 2, explanation 1 provides that an offer of private placement to more than the prescribed number is deemed to be an offer to the public and is to be governed by the provisions of Chapter 3 relating to public issues. Explanation 2 states that for the purposes of this subsection, the expression used in it will have the following meaning. A qualified institutional buyer means one as defined in SEBI Issue of Capital and Disclosure Requirements Regulations 2009 as amended from time to time. A private placement means any offer of securities or invitation to subscribe for securities to a select group of persons by a company other than by public offer through issue of private placement offer letter which satisfies the conditions of Section 42. No fresh offer or invitation is to be made by the company unless allotment under any earlier offer have been completed or that offer has been withdrawn or abandoned. An offer which does not comply with the provisions of this section would be treated as a public offer and would have to comply with the requirements of Securities Contract Regulation Act 1956 and SEBI Act 1992. All money payable towards subscription have to be paid through cheque or demand draft or other banking channels and not in cash. Securities have to be allotted within 60 days of receipt of application money, failing which the application money would have to be refunded within 15 days or else 12% interest would become chargeable. The money received on application is to be kept in a separate bank account in a scheduled bank and also to be utilized only for adjustment against allotment of securities or refund. Offers can be made only to persons whose names are recorded by the company prior to the offer. They should receive the offer by name. A complete record of such offers has to be kept by the company in a prescribed manner. Complete information about an offer has to be filed with the Registrar of Companies within a period of 30 days of circulation of the relevant private placement offer letter. A company offering securities under this section is not to release any public advertisements or utilize any media, marketing distribution channels or agents to inform the public about the offer. After making allotments, the company has to file with the Registrar of Companies a return of allotment in the prescribed manner, including the complete list of all security holders with their full names, addresses, number of securities allotted, and also any other prescribed information. Consequences of default. Any contravention of the section would make the company, its promoters and directors liable to a penalty which may extend to the amount involved in the offer or 2 crore rupees, whichever is higher. The company has also to refund entire money to subscribers within a period of 30 days of the order imposing the penalty. General principles of allotment. In addition to the compliance of the statutory provisions regarding allotment of shares, the company is bound to abide by the following general principles of contract while making allotment. 1. Allotment by proper authority. An allotment must be made by a resolution of the Board of Directors. This duty cannot be delegated except in accordance with the provisions of the articles. In Bank of Peshawar Limited versus Madhoram, AER 1919, Lahore, page 351, it was held that an allotment made by a general manager under an improper delegation by the directors was held to be void. In Pasurala Sannyasi versus Guntur Cotton, Jute and Paper Mills Company, AER 1915, Madras 325, it was held that where the article so provided, an allotment made by secretaries and treasurers was held to be regular. 2. Within a reasonable time. The allotment of shares should be made within a reasonable time. 3. Must be communicated. The allotment must be communicated to the applicant. 4. Allotment must be absolute and unconditional. Allotment must be absolute and in accordance with the terms and conditions of the application, if any. In Ramambhai versus Ghasiram, ILR 1918, 42, Bombay, page 595, it was held that where a person applied for 400 shares on the condition that he would be appointed as cashier of a new branch of the company, the Bombay High Court held that he was not bound by any allotment unless he was so appointed. The applicant must promptly reject the allotment when shares have been allotted to him without his condition being fulfilled. Acquiescence on his part would amount to a waiver of the condition. In Hargopal versus People Bank of Northern India Limited, AER 1935, Lahore 691, it was held that where a shareholder accepted or pledged his shares, he was held to have lost his right to insist on the condition in his application. Section 56. Transfer and transmission of securities. One of the main advantages of doing business in the form of a company is a shareholder in a company can transfer his shares easily. According to section 44 of the Act, shares or debentures or other interest of a member in a company shall be movable property capable of being transferred in the manner provided by the articles of the company. The regulations of the company may impose fetters upon the right of transfer. Section 58, subsection 1, restrictions on transfer of shares in private companies. Articles of a private company always provide that shares can be transferred to outsiders only if no existing member accepts them at face value, are called preemption clauses, where no existing member accepts the proposal. Transfer in favor of an outsider should be allowed. Procedure of transfer. The transferee is the proper person to apply for registration of transfer, but the transferor may also apply. A transfer of shares is completed by registration with the company. The following conditions must be fulfilled before a company can lawfully register a transfer. 1. The instrument of transfer must be executed both by the transferor and the transferee. The instrument must specify the name, address, and occupation, if any, of the transferee. It should also comply with the requirements of the company's articles. 2. The instrument of transfer should be duly stamped and dated. 3. The instrument should be delivered to the company along with the certificate relating to the shares transferred. It has to be presented within 60 days from the date of execution. If the share certificate is not in existence, the letter of allotment of securities should be filed. 4. The instrument of transfer should be in the prescribed form. The proviso to section 56, subsection 1 says that where the instrument of transfer has been lost or it has not been delivered within the prescribed period, the company may register the transfer on such terms as to indemnity as the board may think fit. 5. According to section 56, subsection 3, where the application has been made by the transferor alone and the shares are only partly paid, the company should inform the transferee about it, and if he makes no objection, within 2 weeks the company should register the transfer in his favor. 6. According to section 56, subsection 5, a legal heir to shares can transfer them without having first to get himself registered as a shareholder. 7. The transfer should be approved at a valid meeting of the company's board of directors. 8. Judicial or quasi-judicial interference in transfer matters. In the following circumstances, however, there can be judicial or quasi-judicial intervention. Mala fide, where it is proved that the directors have not exercised their power of refusal in good faith and for the benefit of the company. B. Inadequacy of reasons. When the directors passed an order without giving any reasons, power to refuse registration and appeal against refusal. Section 58, subsection 3 to subsection 6. Section 58, subsection 2 specifically declares that securities or other interest of any member in a public company shall be freely transferable. A company refusing to register a transfer on any grounds whatsoever is required by section 58, subsection 1 to send within 30 days a notice of the refusal to both the transferor and transferee or the person claiming transmission. The company must disclose reasons for such refusal. The transferor or the transferee can prefer an appeal to the NCLT against the refusal. The appeal must be lodged within 30 days of either the notice of refusal or where the company has not given any such notice within 60 days from the date on which the papers were lodged with the company, as the case may be. An opportunity must be afforded to the transferee, transferor and the company to make their representations. The refusal on a consideration of the whole case does not seem to be justified, the NCLT will issue an order to the company to register the transfer, which must be done within 10 days of the receipt of the order. When the requirements of section 56 are complied with, the company registered the transfer. The name of the transferor is struck off from the register of members and that the transferee's name will be substituted in the register of members. Section 53. Issue of shares at discount. Section 53 of the Act prohibits the company to issue shares at discount. Any such issue is void. It provides penalty for violation of section. This section makes exception for issue of sweat equity shares under section 54. Section 54, sweat equity shares. According to section 2, subsection 88 of the Act, sweat equity shares means such equity shares as are issued by company to its directors or employees at a discount or for consideration other than cash for providing their know-how or making available rights in the nature of intellectual property rights or value additions by whatever name called. The section enables companies to issue shares in lieu of services. The shares should be of a class which has already been once issued. The issue should be authorized by a special resolution at a general meeting of the company. The resolution should specify the number of shares and their current market price, and also the class or classes of directors or employees to whom they are to be issued, and consideration for the sweat equity shares proposed to be issued. At least 1 year must have elapsed between the commencement of business by the company and the date of such issue. Section 40, subsection 6, Underwriting Commission. The section provides that a company may pay commission to any person in connection with subscription to its securities subject to conditions as may be prescribed. The Act also permits the company to pay a brokerage as the payment is lawful for the company to pay. Section 52, Issue of shares at premium. If the market exists, a company may issue its shares or securities at a price higher than their nominal value. There is no restriction whatever on the sale of shares at premium. Premium may be received in cash or in kind. The share premium amount should be carried to a separate account to be known as the securities premium account. Liberty is, however, given to use the fund in the following ways. It may be applied to issue to the members as fully paid by way of bonus shares from the unissued shares of the company. It may be used to write off preliminary expenses. It may be used to write off expenses of commission or discount account. It may be spent in providing for the premium payable on the redemption of preference shares or debentures of the company, for purchase of its own shares or other securities under Section 68. Section 36, Penalty for fraudulently inducing investment. A person who either knowingly or recklessly makes any statement, promise or forecast which is false, deception or misleading, or deliberately conceals any material facts for the purpose of inducing a person to enter into any agreement for acquiring, disposing of, or subscribing for, or underwriting securities is to be liable for action under Section 447 for fraudulent conduct. Section 38, Personation for acquisition of shares. If any person makes or abets the making of an application in a fictitious name to a company for acquiring or subscribing for its securities, is liable for action under Section 447 for fraud. I hope you enjoyed this session, and we will meet in the next session.